much. In the meantime, we have some technical issues, so our colleague will work in the background, and I will present Professor Mathieu's speech. Okay, so the nation refers to the idea of a people, not a sum of individuals, but people carried to use, renounce, expression by a collective will to live. This notion of people is defined by a voluntary adhesion to a common history, values, and project. These states have adopted constitutions. These constitutions, in fact, contain three types of norms. Institutional provisions that essentially concern the way in which power is exercised, rights and freedoms, and values like dignity, secularism, and so on. The last two categories of which may overlap, but not necessarily. Although their scope and universality can be discussed, fundamental rights are born in a national framework. Human rights were born in the state framework, even if today their development contributes to questioning these state frameworks. The notion of values is very present in the EU treaty. The formulations are not without ambiguity. On the one hand, these values belong to the common European heritage, which necessarily means the European states. This tends to consider that European values are the common denominator of national values, and that these European values only exist insofar as they are shared by all EU states. Furthermore, a respect for constitutional identities is affirmed. This should result in a dual system. On one hand, that comes under the common European identity, and on the other hand, what comes under national identities. For example, values specific to one state and not necessarily shared by the others. For example, family, secularism, and so on. But the system does not work like that. On the one hand, the chapter of fundamental rights and of the European Union defines in very broad terms what the common values are, and the text of the EU treaty refers to the European Court of Human Rights. As a result, the EU is not only determined by the existence of common values, but also produces common values. However, the new system of values, disconnected from the national melting pot, is arbitrarily and authoritatively manufactured by European bodies, in particular judges who are devoid of any national roots and democratic legitimacy, and who place themselves above national law. The most important aspect of this is the broad power of interpretation that judges give themselves with regard to very general principles such as the rule of law or the principle of non-discrimination. Although there is a broad consensus on these values in theory, it is clear that they can refer to very different contents. If we take the example of the rule of law, this concept is in fact a formidable instrument of assimilation. If respect for the rule of law, which essentially implies respect for the individual and his or her protection against arbitrariness, is really part of the common European heritage, it can be used to impose ideological conceptions. The challenge facing jurists in particular consists in articulating the requirements resulting from this movement of internationalization to which states have adhered by means of treaty provisions and the protection of national identity, which justifies the very existence of the state. The guidelines that I, as Professor Mathieu, will retain are as follows. On the one hand, it must be ensured that states are not imposed constraints to which they have not freely adhered, and that they retain their free will regarding what falls within the scope of their national identity. On the other hand, states must be subject to compliance with the commitments they have undertaken. The question is then obviously how to articulate the protection of these two identities. The problem is that the relationship between international law and national constitutional law does not lend itself to a single hierarchy of norms, which would lead to the creation of a federal constitutional system. First of all, it is necessary to redefine the relationship between national and European competencies. This definition must be the work of politicians. It is a question to clearly determining what competencies should be entrusted to European structures and what competencies and powers should remain in the hands of the states. In order to do this, a distinction must be made between what comes under the heading of European identity, which justifies the association of a number of states, and what comes under the heading of national identity. It should then be admitted that the affirmation of a principle of identity constitutes a reservation to the absolute prevalence of European orders over the national order, a prevalence that is fixed by the treaties and is only valid because it is accepted by national constitutions. Move from an obligation of submission to an obligation of constructive dialogue between national courts and European courts. If conflicts are not resolved, or if, according to the state concerned, the solution of the conflicts with a fundamental principle recognized by the constitutional order, the political authorities should be given the final say in the matter. Thank you very much.